using the questions and chat features in the toolbar on the right-hand side of your screen. Please note that this is the only way to interact with us today, as all attendees will be muted. If time permits, we will give our presenter an opportunity to respond to questions at the end of the presentation. This presentation, as are all of FAIR's webinars, will be recorded and posted on the FAIR website in approximately 7 to 10 days. I'd like to give special thanks to our supporting sponsor for this webinar series for adults with food allergies. This webinar was made possible through generous support from Mylan. I'd like to introduce our speaker. Our speaker today is Mary Vargas. Vargas is a partner with Stein & Vargas, LLP, a civil rights firm committed to the principle that all people have full and equal access to all parts of American society. Vargas advocates for individuals who were discriminated against on the basis of disability through high-stakes federal court litigation and is committed to ensuring full and equal access for all individuals. She has litigated cases pursuant to the Americans with Disabilities Act and the Rehabilitation Act throughout the United States, achieving important victories that have advanced the rights of individuals with disabilities. Vargas is a 1998 Skadden Fellow and a 1994 Truman Scholar. She is the recipient of the Advocacy for Persons with Pain Award from the American Academy of Pain Management. Vargas co-founded the Allergy Law Project and has a special interest in the rights of individuals and families impacted by food allergy. And without further ado, I will turn it over to Mary Vargas.
Hello, I'm privileged to be talking with all of you about food allergies and discrimination based on disability today, which are two topics that matter to me both professionally and personally. I'm a disability discrimination lawyer by training, and I was a disability discrimination lawyer first before I became part of the food allergy world. For a number of years, I focused on high-impact litigation. That's litigation that's trying to change the law and make it better for access for people with disabilities. And I did that at the National Association of the Deaf, where I represented people who were deaf and who experienced discrimination based on disability. That was all before going into private practice. So we opened Stein & Vargas in 2009, and when we started our firm, the vision was that we would take cases about which we were passionate and advance the laws in ways that mattered to us and give voice where we saw an opportunity. So it's no small irony that during the first year of our practice, my youngest son was diagnosed with a peanut allergy and subsequently experienced his first of what's now been 4 anaphylactic reactions. As a disability rights lawyer, this was a humbling experience. Being Perry's mother taught me about discrimination in ways that a lifetime of legal practice could not. As a family, we've been turned away from restaurants. We've wrestled with education, educational access, and we've been turned away from summer camps and other programs. So for me, while this is all legal, it is also all personal. I know as a lawyer and a parent that having rights is not the same thing as being treated fairly. And so from that perspective today, I'm going to lay out the basic legal protections that exist for employees under federal law, and particularly in the context of individuals with food allergies in employment. And we'll open the floor for questions later to the extent, and answer as many to the extent we have time. So when we're talking about employment rights under federal law, we're primarily talking about 2 federal laws. Both of them you've probably heard of before. One of them is the Americans with Disabilities Act, and the other is the Rehabilitation Act. If you've had to advocate for a child with food allergies in school, you know about the Rehabilitation Act. It's typically called Section 504 in the school context. In the employment context, it's usually a different part of the Rehabilitation Act that applies, and that's something called Section 501, and that's what protects federal employees. So stepping back, who does federal disability law protect? What employers does it apply to? Private employers with 15 or more employees must comply with federal disability rights laws. The same is true for state and local governments, although there's no requirement that state and local governments have 15 employees in order for the laws to apply. They just typically do happen to have that. The federal disability laws also apply to labor organizations, employment agencies, and then, as I said a moment ago, federal employees do not have rights under the Americans with Disabilities Act, but they do have rights under the Rehabilitation Act. Now, employees may also have rights under state laws, and that's an important topic that is state-specific, so we're not going to go into those state-specific questions today. Now, once the federal employment discrimination laws apply, the question is, what is it that employers can't do when it comes to somebody who has a disability? The answer is that they can't discriminate in the way that they hire or fire. They can't discriminate in the privileges and benefits of employment, things like pay and training opportunities, attending conferences. Any kind of employment benefits or services must be provided in a way that is equally accessible for individuals with disabilities. Now the question is, who's protected? Is everybody protected under federal disability law? And the answer is no. There are 3 categories of people, maybe 4, and we'll talk about the possible 4th category in a moment, but primarily 3 categories of people who are protected by federal disability rights laws in employment. The first category is qualified employees and applicants. You don't have to be an employee in order for the protections to apply, with a disability. So if you actually have a disability, you are eligible for protection and rights under these federal laws. You also have rights under the federal disability laws if you have a history of disability. This is probably not something that applies to most folks with food allergies, although it could. It's more commonly seen when you have an employee who had cancer or had a disease in their past which they no longer have. And when the employer sees that, that history of having cancer or of having some other disability, they cannot act negatively against that applicant or employee because of that history. The third category is probably the category that's used the least, and it could apply to somebody with a food allergy. The third category is employees and applicants who are regarded as disabled. So they don't actually have to be disabled, but the employer has to think that they are or treat them like they are. And so a lot of times this would come into play where you have an employer who has antiquated ideas about disability, who has prejudice or assumptions they maybe don't realize they have, maybe they do, and they assume that somebody is disabled and unable to do the job based on something they see in their appearance or some information they have about them that leads them to believe or treat the person as if they were disabled. Which brings us to this sort of special consideration, which is something called associational discrimination. And we're going to talk about this again later. This is one of my favorite parts of disability law. It's not something that's litigated too often, but associational discrimination means that you don't actually have to have a disability to qualify for protection under the law. The prime example of this is when you have a parent without a disability who has a child with a disability. If the parent is treated differently because of their child's disability or because of a spouse's disability, that can be discrimination in violation of federal law, and it's something called associational discrimination. And although it has been litigated, I don't know that it's been litigated in the context of food allergy. It is something that we've litigated in the context of other disabilities, and it's a really important area of law because anyone who knows food allergies knows that it impacts the whole family. And there may be rights there that need to be accessed by somebody who doesn't actually have the disability themselves. Now, on the previous slide, we talked about who's eligible for protection under these laws, and we talked about employees and applicants who had a disability or had a history of a disability or were regarded as having a disability. And in all of those contexts, the person had to be qualified. Qualified is a really important word in the law, and what it means is that you're able to perform the essential functions of the job with or without reasonable accommodation. Typically, employers determine what the essential functions of a job are. Those are the things, those are the aspects of the job that the employee does that are essential to the position. And in order to be qualified for protection under the federal employment discrimination laws, an applicant or employee has to be able to perform those essential functions. They can't say, I can do 3 of the essential functions, but I can't do the 4th. If they can't do all of the essential functions, then they're not qualified. Now, there may be disagreement. Just because an employer says something is an essential function does not necessarily mean it's true. And that's where, particularly in litigation, folks will look at how other people perform the job, what tasks are actually performed on a routine basis, as opposed to something that's just put in a job description that nobody is ever really required to do. And it's also really important to know that the ability of a person to perform the essential functions of a job is judged with or without accommodation. So it may be that somebody can't do the job, let's say answer the phone. Maybe they have a motor disability that would prevent them from physically picking up the phone itself. But with an accommodation, with some kind of speakerphone or some kind of technology, that person could perform the essential functions. So you look at whether someone's qualified based on whether they can do those essential functions with accommodation or without, because in some cases there's no accommodation that's needed. Which brings us to the big question that individuals with food allergies and those that care about them are talking about a lot these days and have been really for a few years. The question is food allergy a disability? Now, when I was preparing for this webinar, I did some research online, and it was interesting to see how much false information there is provided to people about what their rights are and what is and isn't a disability, and what the law says and what the federal government thinks. And this is an area where there was particularly a lot of bad information. There is no such thing as a per se disability. Just because you have a specific disability, a specific medical condition, a specific, you use a wheelchair, you're deaf, you are blind, there's no such thing as automatically being considered disabled under federal law. There are some disabilities where it's an easier question, and there are some disabilities where it's a harder question. But it's always an individual determination. You look at the individual and how their condition impacts their life. And what the law tells us to do is to consider whether the person has a substantial impairment to a major life activity. So major life activities are things like walking, breathing, sleeping. They're very basic things, and I'm sure you can imagine there are many ways that a person with a food allergy, particularly someone who has a history of life-threatening or anaphylactic reactions, would qualify as having a major life activity. Now, there was some litigation before 2009, 2008, some court cases where it looked like people with allergies were being found by the courts not to have disabilities. And this was actually not unique to people with food allergies. It was unique to people with disabilities in general. And so the ADA was amended. It was changed in 2008 to make sure that the original intent of providing broad protection and rights was actually a reality. So with those amendments, I think it's a much more clear question whether an individual with a food allergy qualifies as someone with a disability. And in the case of somebody with, again, a history of life-threatening reactions, and there could be some other things in their medical history that might also support a finding of disability, there is certainly reason to believe that a person with a food allergy could be found to have a disability that would qualify them for protection under federal law. And that's not something that's only my opinion. It's something that we've seen. Some of you may be familiar with the settlement in the case against Lesley University, where the United States Department of Justice came in and looked at how colleges provide access to food plans for students with food allergies and celiac disease. And certainly in that case, the United States Department of Justice would not have been involved unless they considered those folks with food allergies and with celiac disease to be individuals with disabilities. That's not the only example. There are others, but hopefully with the passage of the ADA Amendments Act going forward, we'll see more court cases where the questions are not about whether a person has a disability or not, but are about whether they were provided with equal access and the accommodations they needed to do the job. Which brings us to reasonable accommodations. Certainly, when you have a qualified employee or applicant with a disability, you can't deny them the job. You can't treat them negatively because of their disability. But many of the questions when it comes to employment law aren't about that. Many of the questions are about reasonable accommodations. And that's basically what an employer has to do in order to allow a qualified individual with a disability to do the job. And examples are things like job restructuring, vacant positions. When it comes to somebody who's deaf, it might be providing a sign language interpreter. And when it comes to somebody with food allergies, it might be changes to the work environment to ensure accessibility. Now again, what's not going to be reasonable are changes that alter the essential functions of the job. You have to be able to do those essential functions with reasonable accommodations. There are some exceptions. Something called undue hardship. Employers do not have to make accommodations that would result in an undue hardship. This is not something that's typically litigated. I'm not aware of many, if any, cases where a court has found that providing an accommodation would be an undue hardship in the context of the work that I do, particularly with respect to people who are deaf and hard of hearing, but it's applicable to people with food allergies as well. The reason for this is because in order to determine whether something would create an undue hardship for an employer, you look at the overall size and financial resources of the employer. So not just the particular office where that employee works, not just the particular day or month when they asked for accommodation, but you have to look overall. You know, how many times has this employer really had to provide accommodations over the years? How much have they spent? This particular accommodation, what does it cost? And what effect would it have on the employer overall? So that's not an easy burden for employers to reach. The other issue that comes up, particularly in the context of food allergy, is something called direct threat. Direct threat is a legal term for something that creates a significant risk of substantial harm, either to the employee, him or herself, or to those around him. So you see this come up sometimes in the context of somebody who has a seizure disorder and is working in a factory line. And an employer might say, well, if this person had a seizure while they were working the machinery, they might be injured, or their coworkers, the people around them, might be injured. Now, again, this is an individual inquiry. You have to look at the real facts of the real person involved. It's not based on patronizing attitudes or assumptions about the person's disability or people like them. It has to actually be rational and based on real factual evidence. So if you believe that you've experienced discrimination based on disability, it's really important to know that you have a very short timeline to file a complaint. If you work for a private employer or a state or local government and you experience discrimination based on disability, in most cases you have to file a complaint with the EEOC within 180 days. That is a really firm deadline. If it's 181 days, you're out of luck in most cases. Now, there are some circumstances where the 180-day deadline is extended to 300 days because of state laws based on discrimination, disability discrimination. But you want to know before the 180th day if you fall into that category where you might have additional time, and it's always better to file sooner rather than later, because once you miss that deadline, it's over, it's too late. Now, it's a little bit different for federal employees. If you're a federal employee, again, the ADA, sorry, doesn't apply to you, and you need to look to the Rehabilitation Act for your rights. And under that, you need to go to your EEO counselor, generally within 45 days. And then there's a process that progresses from there. But these timelines are very important to keep in mind. Probably the question I get asked most when it comes to employment and food allergies is, do you tell? And if you tell, when do you tell? And who do you tell? And why do you tell? And how do you tell? All these questions of should you keep it a secret that you have a food allergy, or should you disclose it? And this is an individual determination based on your own employer, your own job, your own disability, your own safety needs. But generally, the reasons you would disclose is if you wanted to ask for some kind of accommodation. You would have to disclose in order to ask for a reasonable accommodation. If you wanted folks who work every day around you to be aware of your allergy, so that in the event that you had some kind of medical crisis, they wouldn't be wondering what was happening to you. They would know. And you might also want to disclose so that you could approach your employer about some kind of allergy action plan. So they would know what to do if they saw you passed out, if they saw you unable to speak or breathe, or your eyes swelling closed, those kinds of symptoms. They would have a concrete plan of what to do. But the reality is, in most circumstances, I personally don't think there's any reason for a job applicant to ever disclose an allergy. It's not a topic that would typically come up at a job interview. Employers are not allowed to ask about disability when they're considering you for a job. They can ask, can you do the job? But they can't ask, hey, I see that EpiPen, do you have a food allergy? And in a few minutes, we're going to talk about some real-life cases involving allergies where people did disclose, and there were some negative consequences. So my advice generally when people ask this question is you don't disclose unless you have a reason to, and it's generally always better to have a job offer in hand before you start talking about accommodations or disabilities. Which brings us to the real-life examples. Now, because of the ADA Amendments Act and the realities we talked about a few minutes ago, how allergies were historically often found not to be disabilities in court. That's changed now. So we're really just starting to see cases work their way through the court system where there are food allergies, and I've included latex allergies here, and some other environmental allergies at issue. So the first example that I provided here is a case called United States versus John Moore Health. And this was a case where the EEOC found, after someone filed a complaint, after a few people filed complaints, that there was cause to believe there was discrimination, and they took an employer, a healthcare employer, to federal court. There were 8 employees who had latex allergies who were offered jobs in this healthcare employer. Some of them, I believe, were nurses and things like that, where they would be potentially around latex. And after these 8 employees were offered the jobs, the employers found out, likely through post-offer medical exams, that these employees had latex allergies. And once they found out about the latex allergies, the employers took back the job offers, and that was that. So the United States ended up settling this case. This is a pretty substantial settlement, $340,000 in 2011, on behalf of those 8 employees with a latex allergy who had their jobs taken back by the employer. The second example, it's a really, in terms of the facts, this is the worst of the cases that I saw in doing research for this this presentation. A woman, an employee with a severe peanut allergy, worked for an employer for a period of years. During those years, she was really subjected to a pattern of, if it was in school, it would be called bullying, harassment and bullying, and really terrible, dangerous treatment, not only by her coworkers, but by her supervisors. So they were aware that she had a peanut allergy, and while she was on the job, there were instances where coworkers would deliberately eat peanut products right next to her, saying they were testing to see whether she would have an allergic reaction. One day she came into work and she found peanut shells crushed and spread all over her desk and her paperwork. And I think probably, in my opinion, the worst part of what happened when she went to her supervisor to discuss all of this. She walked in to speak with the supervisor, and he pulled out a peanut butter Twix bar and began eating it in front of her as she was talking about her concerns. And she did have a number of incidences where she did have the reactions that they were testing for. She had to go to both via ambulance and to urgent care with allergic reactions. And one of the last instances before she filed suit, she was having an allergic reaction. I believe it was in front of her supervisor. And the supervisor refused to even call 911 for her. And she was left to try and call 911 herself as she was in anaphylaxis. So she had a really just horrific experience and nightmare experience. This case was filed in federal court under the Americans with Disabilities Act and progressed for, I think it was about 2 years of litigation. And then it was dismissed off the court docket, which to lawyers means that there was likely a settlement that resulted. And I was not involved in litigating this case. I don't know the outcome, but when you see that, that typically means that there was a settlement. The case did not go to trial. It's another story that many of you may have heard about that, as far as I can see, did not result in a federal court complaint or state court complaint. This is a situation of a woman in Boston who had applied for a job scheduling dental appointments for an outpatient clinic run by Boston Children's Hospital. Now, again, she likely had a post-offer medical examination, which would have revealed that she had a peanut allergy. And once the employer found out that she had a peanut allergy, they retracted the job offer and said she couldn't have the job anymore, which, to me, this is a really interesting example because it's difficult to imagine how any aspect of having a peanut allergy was relevant to scheduling dental appointments for children. Couldn't find any record of this suit ever being filed. I don't know what happened with Ms. Coleman, but this certainly appears to be, an example of where someone was discriminated against based on, fear or misperceptions, or just not wanting to deal with something. The next example is something called Kaufman versus GMAC Mortgage. And this involves a perfume allergy as opposed to a food allergy, but I included it because I think there's a really important lesson to be learned from this case. This case was a loss for the employee. She had her case dismissed in the district court, and then the next level of review is the U.S. Appeals Court. This was in the Third Circuit. So it's one step below the U.S. Supreme Court. And what the court found in favor of the employer. The employee had been asking for accommodations, and she was having trouble specifically because other employees were wearing perfume, and there were some air fresheners with scents being used in the bathroom that were causing problems for her. But there were some facts that really supported the employer here, and that's why it's a really important example. The employer spoke to, there were records that the employer on multiple occasions spoke to other employees who were using products with scents and fragrances and asked them to refrain from doing it and asked employees not to use different scents in the restrooms. And so it's an example of the employer was not just sitting back and letting things go badly. The employer was trying to protect and keep safe and healthy this employee. More importantly, when they talked about what kind of accommodations could be provided, the employer was able to show that not only did they make some accommodations in terms of changing the ventilation around this person's desk, and I believe they had fans, and they had some kind of new vent put in above where she worked. More importantly, they offered to have her wear a face mask that would have filtered out the scents. And she said that it made her claustrophobic. Now, it may be that the court should have looked at that as somebody with two disabilities, but that issue wasn't really addressed by the court. What the court did address was the fact that the employer responded when the employee said, you know, I can't do the full face mask because it makes me claustrophobic. The employer offered her a partial or half face mask, and the employee refused to try it. She said it wasn't going to work, and she wasn't going to try it. And that's almost always a mistake. It's really important as an employee when you're talking with an employer. It's called the interactive process, where you're talking about what accommodations are reasonable and what you need. It's important that you're open and you try the accommodations that somebody offers unless they would put you in danger. Even if you know they wouldn't work, it's important to try them and to engage in good faith in that process. And so this employee, had she tried the partial face mask, you know, maybe it wouldn't have worked, and that might have resulted in a different outcome in the court. But the problem is she never tried. So it's important to interact in a professional and positive way with an employer to the extent you can, and try the accommodations that are offered before just turning them down. Then the last example that I'm providing is another case where the United States sued on behalf of an employee. This person happened to be a UPS driver. This person had a serious allergy to cedar trees, so not a food allergy. But I think it's an interesting example because this is a case where the employee was able to get their case reinstated in the lower court. The reality is employers very often prevail in employment discrimination cases. It's very hard for employees to win employment discrimination cases. And so when you have an example of where somebody with a disability wins in the employment context, you really want to look at that and see what happened. In this case, the person worked for UPS, and I believe they were working in Texas where there were a lot of cedar trees, and they were getting very ill. And their doctor recommended they move someplace where there were no cedar trees. And when they went to their employer and asked that they be relocated to a different location, I think they wanted to go to Cincinnati, the employer said, well, you can just resign your job and reapply there. And so the person did that. And when they reapplied, UPS in the new location told them because they'd resigned, they were not eligible to reapply for a job. And so here this person was applying in a new city with loss of their job and all their seniority, and really stuck. And in this case, the Court of Appeals found that the lower court had made a mistake in dismissing this employee's claims and reinstated the case. Presumably, this case also ended in a settlement. There's no record of the case going to trial. In many cases, particularly where there are strong facts supporting the employee, many cases do end in settlement. I think it's important to briefly mention the Family Medical Leave Act. I talked earlier about rights that people may have who have family members or associates who have food allergies. There may also be rights available to employees under the Family Medical Leave Act. And so this applies to local, state, and federal employers, and it allows up to 12 weeks of unpaid leave to care for a parent or spouse or child with a serious health condition, which for those of us impacted by food allergy know that this could be something we might need. Before we go to questions, I think there's a really important thing to keep in mind, and that's why I put this quotation up here. It only takes one voice at the right pitch to start an avalanche. It's really important for people to know their rights. It's really important for people to advocate. But probably the most important words in this quotation are at the right pitch. As a parent, I know that it's incredibly difficult to advocate when you're talking about the life and safety of your child or your loved one. It's not the same thing as going into the supermarket and saying, you know, there was a coupon in the paper and I want this sale price. It's emotional. By definition, it's emotional. And when something's emotional, we all have a tendency to react more loudly, less rationally, and at a pitch that sometimes makes it hard for others to hear. And so it's really important, I think, and this is something I do myself when advocating for my own child, to recognize and remember before I make that phone call that, you know what, this is emotional for me, this is personal for me. And when I'm talking about my own child's safety or my own loved one's safety, I need to be mindful that I do it in a way that's calm and respectful so that it's most likely to be heard. And so I think that's something in food allergy that's particularly difficult because the stakes are so high, and sometimes you don't get to do it over. And so you beat your head up against the same arguments over and over and over again, and sometimes it's really hard not to go in guns blazing. It's important to go in at the right pitch and to speak softly sometimes in order for your words and your message to be able to be heard. And so with that, I would love to hear some of your questions.
Great. Well, thank you so much, Mary. This has been a very informative and helpful presentation that I hope that our attendees got a lot out of. A few questions have come through, and if you do have questions, now the presentation has completed and we're in the Q&A section. If there's anything that you feel you'd like to ask, feel free to plug that into the chat window or the questions window, and we will try to bring up as many as we can. One question that came through is regarding how someone may work in the food industry with food allergies.
Yeah, this is an interesting question, and this is one of those issues where it hasn't been litigated a great deal, so it's hard to give a definitive answer for that reason. But it's also challenging because, as we talked about before, so much of this is an individual inquiry. What are the individual circumstances of the applicant or employee in question? What is the job involved? What are the essential functions? Now, with that said, I think it's interesting that two of the cases that came up in this context involved candy companies. There was an employee that sued Russell Stover. It was somebody with a nut allergy who was asking not to be exposed to nuts in their employment. And that case ended up as a loss for the employee, but likely for reasons that were not relevant to our considerations. There's another case that was filed against Hershey by an employee with, I believe, again, it was a nut allergy. And they were asking to work in an area where they would not be exposed to nuts. And the employer wanted to put them on a specific line, I think it was the Rolo line, and the employee felt that would not keep them safe because there were, I think at the time, almonds being processed in the same area. So this is something that comes up. There aren't too many real-life examples in the courts, but there are some. And I think the real way to look at it is to first consider, is the person a qualified individual with a disability? If the person is considered to have a disability, then can they perform the essential functions of the job? If the person has, let's say, a dairy allergy, and the job involves stirring the milk chocolate, that's what they're supposed to do all day long. Asking as an accommodation that they do an entirely different thing and still be the milk chocolate stirrer, that's probably not, that's somebody who's probably not able to perform the essential functions of the job, and that's somebody who's asking for an accommodation that may not be reasonable. More commonly, I think this is something where there could be accommodations that would be reasonable, that would keep an employee away from areas that might put them at risk and allow them to do the essential functions of the job. But it really is an individual question where you have to look at the individual facts and circumstances pretty closely.
Great. Another question has come through about when you're working in an office environment, how someone might deal with the lunchroom when a coworker brings in something that they are anaphylactic to. In this particular case, it sounds like they are not permitted to leave the building or eat at their desk.
Well, certainly sounds, based on that information, like it might be a reasonable accommodation to allow that employee to eat somewhere else or to leave the premises in order to eat. Now, there might be reasons why the employer does that. There might be sometimes employees that come into factories, for example, have to go through showers and cleaning processes before they can start working. So there might be reasons why an employer would say an employee can't leave the premises. But I would think in most circumstances that it would be eminently reasonable for an employee who has a severe allergy to ask for accommodations that would allow them to eat safely. If all employees are allowed to eat at the job, well, employees with food allergies should be allowed to eat at the job too. And depending on the facts and circumstances of the person and the job and the employer location, it seems to me there could be many reasonable ways to work that out. And that's an example of why somebody might want to disclose or need to disclose that they have a food allergy. Another example that comes up sometimes similar is storing food and lunches. Many employers provide a refrigerator for their employees to store their food, and it might not be safe for somebody with a food allergy to keep their food in that refrigerator. So if the employer is going to allow the allergens that the employee is allergic to into the refrigerator, it might be reasonable for them to provide a small refrigerator or some other area where that employee could keep their food safely.
Great. Another question came through about companies in sort of office environments that may treat their employees to lunch. They pay to feed everyone lunch, and they send around a specific menu, and there is nothing for an individual with food allergies to eat. They're not willing to stop anywhere else to pick up something that they can eat, and the question is sort of how can this be addressed?
Well, I think there are two questions. There's always the question of what rights does the law provide, and then there's the harder question of what's the best way to handle the problem with your employer so that you have a relationship going forward that's functional, not only with your employer but with other employees. In this example, when an employer is providing a benefit to other employees, they need to provide that benefit to all employees. They can't deny access based on disability to one individual. So if an employer is providing meals to all employees, it's fair, it's reasonable, I would think, for an employee with a food allergy to request as a reasonable accommodation that they be provided some alternate food, or perhaps even be permitted to bring in their own food.
Okay. Another question came through about the use of epinephrine within the workplace and suggestions that you may have about having coworkers educated on learning how to use an epinephrine autoinjector, and have you heard of any instances where coworkers were unwilling to administer epinephrine because of concerns of doing it incorrectly and liability issues?
Well, the case that we talked about a few minutes ago, the really awful one where the woman was experiencing an anaphylactic reaction and the employer refused to even call 911. That's probably the most comparable example that I'm aware of. I don't know that there's any obligation for anyone in an office setting or an employment setting to provide epinephrine to an employee. This is one of those things where there might be a very good reason to disclose, certainly to trusted coworkers. And it's an example of where you might want to ask for help rather than trying to demand or assert rights. In many cases, I think there are coworkers who would welcome knowing what to do if an employee coworker was having an allergic reaction. And so there are certainly good trainings that are available that can be provided to employers and to in workplaces for those who are willing to step up and be willing to put into place an allergy action plan in the event somebody was having an allergic reaction.
And a similar question is related to inquiring if you know of any cases or movements to have auto-injectors available in workplaces similar to defibrillator machines and things like that?
I'm not aware of specific efforts. I know there are efforts out there. It generally is a state-by-state consideration where folks are looking at the state laws that would allow this, or in some cases not allow this. So, it's a great opportunity, if this is something that you believe in, to look at the National Food Allergy Organization and to go to FAIR and find out what advocacy is local to your area and what ways you might be able to get involved in efforts in your state to advocate for this. We've certainly seen stock epinephrine laws escalate like crazy in the last few years, and I know there have been some efforts. One example that comes to mind, Disney World now has EpiPens available, and so that's certainly a huge employer and might be used as an example of really increasing access to life-saving treatment for everyone.
And a similar question sort of came up in last month's webinar related to stock epinephrine on college campuses. And FAIR does have, we have updates out pretty regularly in terms of stock epinephrine's expansion to higher education institutions and workplaces and places like camps. And so we would encourage anybody that's interested in more about this and getting engaged in that to go to our website and sign up for the FAIR Advocates Network as well. Another question that came through is sort of related to the essential function question, and I guess that this may be a little bit of a difficult one to respond to since it is sort of an individual case, but they have an employer that is requiring them to attend luncheons and business functions that require food, and they wanted to sort of question if that might be an essential function or how they might determine if it is in fact an essential function of their position.
That's a really good question, and I think it's a good example of where it's important to know what qualified means. Qualified means you're able to perform the essential functions of the job with or without accommodation. It sounds like this employee would be able to go to lunch functions or meals in most places if they were allowed to do so with the accommodation of either bringing their own food, or an accommodation might be that they would choose the location, or they would have an opportunity to look at the menu ahead of time and make sure there was something they could safely eat. It seems to me that there are many ways that going out to eat with clients, which I understand can be a very important part of some jobs, that could be accomplished with accommodation, and so that this employee would be able to do that essential function. They just might not be eating, if they're allergic to sesame, they might not be eating the sesame seed bun wherever they're dining out with clients.
Great. One more question that is, again, sort of revisiting food being provided, but this particular inquiry, they work in the restaurant industry, and it sounds like the company, as sort of a courtesy during busy holiday seasons, will order pizza to feed everyone because they bought everyone food and no one can order food. And there are laws in place that as a restaurant they cannot bring in outside food. How is someone to deal with this? And in the past, I guess that they're speaking from professional experience, that they would not be allowed to eat at all.
This is a question that's been coming up more frequently, especially in the last few weeks. We've seen it come up at the Allergy Law Project and elsewhere. What food can you bring into a restaurant? So before I directly answer that question, let me just veer off for a minute and say that I don't necessarily agree that the restaurant would be prohibited from having somebody eat outside food. You'd have to look at your state health laws to see what's actually required under the health codes. But in most cases, those health codes and state health laws would govern the food that the restaurant would prepare and serve and sell to customers. And so the food that a person brings in to eat there, whether they were a customer or an employee, I don't want to assume automatically that wouldn't be allowed under health codes. I think that might not be true in many cases. I think it would be possible for a person to bring in food. With that said, to more directly answer your question, if an employer is providing food to their employees, seems to me that's a benefit of employment. And if they're not providing food or allowing the person to eat their own food, it seems to me like that might be discrimination, and that the employee might want to think about approaching the employer and explaining exactly what the issue is, because sometimes, just as we see in other contexts, sometimes people just don't understand. They just don't get it. And sometimes if you approach an employer and explain, you know, I have this food allergy, it's not just that it makes me a little bit itchy, but I really can't eat this. I want to work, I want to do the job really well, I love my job. On these days when I'm working these long shifts and you're bringing in food, it's really a problem because I can't eat it all. And what can we do to address this? Could we bring in alternate food, or could I bring my own food, or could I be given, you know, enough time that I could go get food and eat it outside in order to keep doing my job? And I think the employee would be on pretty strong footing in asking for that accommodation.
Great. Well, that about wraps it up as far as questions go. I want to once again thank Mary Vargas for coming to us today and presenting for this webinar and sharing her time and her expertise with us today. Our next webinar is going to be with Dr. Jeanne Herzog, who recently came from speaking at our National Food Allergy Conference and did a wonderful job. She'll be presenting on managing the emotional impact of living with a food allergy. This presentation will be held on Wednesday, June 17th from 1 to 2 p.m. Eastern Time. Member registration opens Friday, May 29th, and general registration opens Monday, June 1st. This webinar will help attendees sort of understand the emotional impact of living with a food allergy and also teach how to develop an emotional safety plan to help prepare for and reduce that impact. That concludes today's webinar. Thank you all for joining us, and we hope to see you again next month.